Hi everyone. I think my voice carries, but fair enough. Just a bit of background. I hold a PhD in computer science and I'm an advocate of the High Court. I represent SAFACT, or the Southern Africa Federation Against Copyright Theft, and SAFACT's primary role is to protect intellectual property rights of its members. They include ranging from Ster-Kinekor, Times Media, MultiChoice, Indigenous Films, numerous international studios, Sony PlayStation, and the publishing industry, to name but a few. Now, our goal is the enforcement of copyright, and to this end, we feel fairly strongly that Section 13A needs to be revised. I will be very brief and very quick, and I will not rehash what some of my learned colleagues have said. But Section 13A deals with temporary reproduction and adaptation. It reads as follows. Any person may make transient or incidental copies of a work to enable transmission of the work in a network between third parties by an intermediary or other lawful use. The term here is or. Now, furthermore, to adapt the work to allow use on different technological devices, such as mobile devices, as long as there is no independent economic significance to these acts. The problem with this provision is, should a work be temporarily reproduced and transmitted over the internet or streaming device using a set-top box, can anybody be held liable? So this goes to enforcement. The need to rely on the meaning of the phrase, as long as there is no independent economic significance, for which there is no case law or no precedent. What this means is that Section 13 will be widely open to misinterpretation. Now, although the wording of the 2017 bill is somewhat different, it does not address any of the concerns already raised. Read the same provision for the 2015 bill. These concerns were raised by the entertainment industry, and they were also raised by the Centre of Intellectual Property down in Stellenbosch, initially headed by Prof. Jooste. The provision creates the strongest possible defense to wholesale copyright infringement. So the court will be burdened with dealing with this defect on a case-by-case basis. So what it really comes down to is your ISP, when you already have provision 75, section 75 of the ECT Act, going towards mere conduit status. Now, why is this section here if that's already provided for, and why do we now label it as an arbitrary term, independent economic significance? Now, generally, and I'll briefly perhaps touch on that closing, but Section 12 of the Principal Act is amended by Section 10 regarding the concept of fair use in respect of a work or performance of said work. Specifically, copyright is not infringed when, and I read Clause 10, Subclause 1A, 6. Expanding access for undeserved populations. Again, undeserved. What does it mean? Would the use of a streaming device fall under this amendment should the provision be met? So would the student classify as an undeserved population? And ownership is clearly protected by the bill. However, such a blanket exception could undermine the rights of copyright owners and does little to strengthen the current Act's protection. When taken as a whole, it is clear that the bill does little. And the provision for temporary reproductions will result in an ISP, as I mentioned, for example, not being held liable for infringing when transmitting a copyrighted work between a user and a source. The issue is, of course, why include such a section when Section 73, and I apologize, I said 75, of the ECT Act frames such liability much more clearly and judiciously. When that's really all we'll have, many of the other issues have been dealt with. It's an interesting piece of legislation. But I believe there's still some way to go to rectify some of these issues, which will impede the industry's ability to enforce their rights, the rights of authors, the rights of artists, collection societies, etc. Thank you very much.